I extend a very warm greetings to all the delegates who have come from abroad on my behalf, on behalf of the Government of India. It is the third BRICS Legal Forum. You have a great legacy. You know, these 5 countries came together because there was something truly extraordinary for them to share about. My misfortune that except Brazil, I have visited all the countries many times. And I promise I will go to Brazil very soon. About 3-4 invitations came, I couldn't go. But, but in particular, I had gone to Robben Islands in South Africa, where Nelson Mandela was in jail for 27 years. I went to his cell and almost became emotional. A man remaining in solitary confinement for 27 years. Yet he could never lose his sense of humor and the profound commitment that apartheid has to end by means which are Gandhinian. These are important philosophical underpinnings which create a bedrock of infinite unity between all these countries. As I see these 5 countries, they are coming together not only because they are emerging economic powerhouses of the world. They occupy 30% of the land area of the world and 42% of the population of the world. A journey which began with hardly 10 billion in 2002 in FDI flow has risen to almost 21% in 2014. And there is inward flow and outward flow also. Companies of these 5 countries today have become a beacon of excellence and growth world over. Well, ladies and gentlemen, I see these 5 countries seeking to reorient the world order, designed to extend their area of influence. And that is one commitment which greatly influences me. The whole world, in a way, right from Industrial Revolution, has evolved with certain well-accepted conventional concepts. This can be done only by the West. This can be measured only by Western concepts. These initiatives can only flow from the West. This basically, when you talk of globalization, these 5 countries collectively represent a quest to have a more equitable global world. That's the larger concept I understand, which is there, and I'm indeed very happy, Mr. Chairman, that with this theme of BRICS India is developing legal frameworks for building responsive, inclusive, and collective solutions. If BRICS are coming together, there is investment, there is a reform. If you reflect upon these countries, all these countries opened their gates for FDI, reform, investment in 90s in and around. Some a little earlier, like China. But reform is important. Integration with the global world is important. FDI is important, and promoting entrepreneurship is important. With this framework, all the 5 countries opened their gates. And today, all of them in their own way are becoming economic powerhouses. I gently reminded Mr. Venugopal when he inadvertently slipped my designation of being the IT Minister of India also. He has given me certain rights, don't mind it. Just on a lighter vein, for the first time, I assisted him in the year 1983, when I had just begun my practice in Patna High Court. After 33 years, he hasn't changed. And I think all my friends from the bar would confirm that he has remained the same Mr. Venugopal in his appearance. And my good luck that we have become very close friends now. But you know what is important is how India is changing. And for my delegates of all the rest 4 countries, I would like to share that these 5 countries are becoming economic powerhouses also in the field of IT, information technology. Ladies and gentlemen, this is the world of information. Information is power. This principle they accepted quite early. I can share very little with you. India has a population of 1.25 billion plus. In that, we have 1.03 billion mobile phones. We have got 1.05 billion Aadhaar, verifiable digital identity of every Indian, kept under very safe conditions. And we have got nearly 500 millions internet, about 50% is mobile based. In the last 2 years, we have added mobile phone in India equal to the population of France and Italy. That's how we operate. Similarly, all other countries are also extending their IT profile for good governance, for transparent governance, delivery, and also inclusion. That being the scenario, obviously, it is something good. But how does the economic march of the BRICS countries match the legal dispute resolution? That is something very important for this gathering to consider. And therefore, this particular topic which we have decided the theme of this conference requires very relevance. How I see it, there is some mismatch. And this I am saying, this is my 3rd term as the Law Minister of India. I had the privilege to serve earlier also in Vajpayee government and earlier in the Modi government. And I see that while the world is getting reformed, the world is opening up, but the dispute redressal mechanism still retains the slant of the old. How do we change that? We had investment treaties with many countries. Obviously, money has to come, there has to be a treaty. But how it happened that most of the BRICS countries were constrained to revisit those investment treaties. I was just going with some of them, and I need to share with that. South Africa was constrained to propose a domestic legislation to cover investor-state disputes. You came with a draft promotion and protection investment bill to provide a framework for protection of all investment in South Africa. In Brazil, the government was constrained to bring a joint committee and ombudsman comprising government representatives of both parties. In India, we had 83 investment treaties. We ratified 73 out of the model of 1993. But now there is a need to revisit under the model BIT of 2015. Why it is happening? Indonesia, Malaysia, other countries are also seeking to change the entire legal architecture of investment treaties world over. Is there something wrong? Yes, it is. And how do we see it? We see it in the way the dispute redressal system is working. And here I would like to take from what my distinguished friend Mr. Lalit Bhasin mentioned. How is it that 69.8% of arbitrators of all the disputes belong to developed countries or the first countries? Why? At least I can say of my countries, a very robust, outstanding free legal profession, eminent lawyers, outstanding judges. We're very proud of their intellectual capabilities and also integrity. But how is it and why is it that 69.8% of the arbitrators are always from the developed countries? Why is it that we see only QC barristers hopping from one arbitrator to other? These are questions to be addressed. These are questions to be explained. And I think it is important that this particular conference will address that. The second is the issue of economic cost of litigation. How do we balance the right of the investors to get his dispute resolved and the right of the sovereign government to regulate and also ensure that its own social commitments are taken care of? Should we consider that domestic issues of social inclusion will not get the due priority in the entire dispute resolution process? These are questions which are crying for an answer. And similarly, the way damages and the penalties being imposed by some of the arbitration proceedings, I'm sorry to say, is mind-boggling. If that is the model to be followed world over, it will lead to a dislocation of economies of many countries. Suppose a particular contract, and I'm consciously flagging that issue to you, a particular contract is tainted, but a foreign investment has come. Suppose there is an element of that. The arbitration proceeding will not go into those things in detail. Sometime or the other, you will have to go into these questions. The government's right, the right of regulations, the right of addressing the concerns of the poor and underprivileged, and adopting a balance between the right of investors and the commitment of the countries where the investment is coming in a fair, transparent manner. These were some of the issues I thought I must flag to you. Yes, we in India are very keen to have a robust arbitration mechanism. We are doing our best for that. Similarly, I would like a proper dispute redressal mechanism to be fast-tracked in all of your countries, which is being done. I'm very happy, including legal literature. But what would be the happiest day for me, ladies and gentlemen, if the BRICS countries can come with an alternative, constructive, efficacious dispute model ecosystem, which is more relevant to emerging economies. That is what the need of the day. Thank you. My warm greetings. Welcome once again.
Thank you, Honorable Minister. In a very short address, you have covered such an enormous field. And I must inform here two things. One, that this is an action forum, not just an academic discussion forum. So we are taking concrete steps to bring the arbitration and dispute resolution leadership and hub in the BRICS countries. And today, after the speech of Honorable Justice Mishra, we will be launching the New Delhi Arbitration Center for BRICS and emerging economies. And also, a very strong element of the New Delhi Declaration we are going to sign is on the treaty arbitration, the unfairness of it, and we are together trying to assert that when investors globally make their investment decisions, they calculate all their profits and losses. They cannot then later on transfer it to sovereign governments as damages because things have not worked out the way they thought and planned. And we are saying that the rights of local populations on the natural resources, impact on environment, are all inherent rights which should be recognized as rights equivalent to in Universal Declaration. And that's why these treaty arbitrations cannot take precedence and ultimately put indirect costs on the local populations for the benefit of whom these investments are sought to be made. So this is the part of the New Delhi Declaration. Now, I will request our chief guest of today, Honorable Justice Deepak Mishra, a very senior judge of Supreme Court of India, to deliver his address.
Honorable Mr. Ravi Shankar Prasad, Union Minister of Law and Justice, Electronics and Information Technology, Mr. Rohatgi, London Attorney General for India, Mr. K.K. Venugopal, Senior Advocate, the President of the All India Bar Association, Pinky Anandji, heads of the delegations, dignitaries on the dais, Justice Ganguly, the former judge of the Supreme Court, and Mr. Indra Banerjee, Judge of Delhi High Court, ladies and gentlemen, and my jars of future bar. Before I read my speech, I must express my concern about what the Honorable Minister said. I entirely share the perception there has to be efficacious and effective alternative dispute resolution system. I've been telling at places there has to be a climate of settlement and friendly investment and friendly settlement. These are to be defined. It can't be described. The type of arbitration matters the court gets, sometimes it's mind-boggling, shocking, in a way perplexing. I think Mr. Rohtagi would stand testimony the same. Coming back, I must presently confess that it's a great delight to share my thoughts in the third BRICS Legal Forum on developing legal frameworks for building responsive, inclusive, and collective solutions. The diverse societies and countries in almost all spheres have come out of their limited spheres and share a sense of universality. It is because the problems that have arisen in present time are universal. Earlier, it was not so acute. Be it poverty or violation of human rights or change in the climate or environment, or for that matter, commercial transactions, all demand common solutions because each solution hurts and affects all of us if remains unsolved. The solution to such diversified and colossal problems lies in sovereign countries coming to a common understanding of these problems and working out an acceptable, concrete solution. The success of solution, as I perceive, depends on objective and unbiased understanding of the reality, causes, options, and implementations. This necessitates extensive study and analysis from the local to the global, from microcosm to the macrocosm. The expected solution can be reached only by participative and inclusive scrutiny, and such scrutinization to be meaningful has to encapsulate the socio-economic perspective of the group and committee of the nations involved. The Brasilia and Shanghai declarations of BRICS Legal Forum have been quite emphatic on affirmative steps in the search for solutions for taking assistance from professionals in the field of law and academicians from the universities and other sources. All of them are embedded in the golden conception that unite us, all of us, definite many diversities, that is, the rule of law. The human history of last 200 years, an onslaught of incomparable catastrophes in the forms of 2 world wars, have taught mankind that violence is not the solution. I would say idiotically, something that nature is ordinarily violent and destructive, and tranquility and equanimity is a dream and wish. But said thinking is absolutely absurd and perverse, and that cannot be allowed to have any space today. It's absolutely contrary to the idea of solution. The solution lies in understanding the universalities of the problem relating to environment, climate, change, and globalization, the diversities of culture, commerce, economic models, various dimensions of human rights, and immense possibilities striving and finding the solution to diverse and conflicting interests and requirements through mutual negotiations. It has to be borne in mind that the last century has witnessed independence and birth of nations, nation states that has been breaking of barriers relating to trade that emphasize